What's up, everybody? Welcome back into the episode of The Lawyer You Know. And we've got a lot to talk about today. Alan Jackson writes a letter roasting Cox and how he handled the Dever situation, calls him a liar flat out. How is this going to affect Cox's career? Why is Alan Jackson doing this? Is it just for the PR, or is there some real justice behind this letter? And who was actually telling the truth, Dever or Cox? And what corroborating evidence do we have of that? And how did we get it? More importantly, and then we're also going to go through the motion where the Commonwealth is actually trying to block some of Proctor's phone data. And you may be surprised to hear that I actually agree with part of it. But there are certain issues that could create major problems for Proctor, according to Mark Betterow, maybe even some criminal liability there. So we're going to talk about all that. We're going to answer your questions. Let's get to it. All right, so the first thing we're going to talk about is this letter. But the teeth to this letter, the evidence proving who is telling the truth, Kelly Dever or Commissioner Cox, came from someone that, I've seen on Twitter as Marbury versus Mad, but she's actually a real lawyer. Corey Hopkins is her name. And she did a little public records request, which should be easy and should be no problem, and the public documents should be turned over. But of course, the Commonwealth tried to block her from doing that and not allow her to get these public records. So she had to file a lawsuit and fight to get a lot of records, some of which are going to be used in this one piece that we talk about. And I just want to take a second and highlight how unfair the system can be sometimes, and how it shouldn't be like this. You shouldn't have to file lawsuits to get public records. And the fact that Corey is an accomplished lawyer who is able to do this, who has the wherewithal and the resources and the ability to do this, is not how it's supposed to be. It shouldn't just be accessible to lawyers. Now, luckily, we have people like her who are willing to do this and who are willing to get the documents, make them public, dig through them, sift through them. If you think that's easy, if you think that doesn't take a ton of time, you're wrong and you've never tried to do that before, especially because she probably also has a real job that she's doing this with her additional time, trying to shine a light on the darkness here, shine a light on the corruption and the problems in the Commonwealth, of course, of Massachusetts, but and beyond. Because there are so many things that we fight about in the law and with rules. And I'm not talking politics. I'm talking just people, human beings. And access to the courts is one of the major problems people just don't know about. And this is an example of that. Because there's, of course, problems with access to the courts when it comes to money, the ability to hire a lawyer, the ability to even know what to do, but then the ability to get over obstacles that are put before you by lawyers who know what they're doing, or other people who are part of the system. And you don't know how to navigate that. You don't know how to get through that. Lawyers do. That's not how it should be. And this is an example of that we're going to keep an eye on. And that's something we'll continuously talk about on this channel. But I wanted to give her a shout out because she's doing amazing work that just takes time and energy and effort that a lot of people either can't or won't do. Lisa, thank you for gifting 5 Lawyer You Know memberships right off the bat here as we jump into the letter from October 27th, 2025, from our guy, Alan Jackson. And it's to the Honorable Michelle Wu, Mayor, and Enrique Zuniga, the Executive Director. Immediate Brady listing and post-review Commissioner Michael Cox. Dear Mayor, Madam Mayor, and Director Zuniga, Boston Police Commissioner Michael Cox has been caught in a lie, and not a small one. So no holds barred. Jackson is just coming out swinging. There are still, of course, some ways people can try to weasel out of what they said and what could still possibly be true. But no matter what, whether you support the Commonwealth, whether you think Karen Reed's guilty, whether you don't, this does not look good for Commissioner Cox. And we have to remember, when we're kind of having a juxtaposition of Kelly Dever and Commissioner Cox, I said when we broke down Commissioner Cox's interview where he said, I didn't know Kelly Dever had any connection with Karen Reed, basically saying she's lying. We didn't meet and talk about the Karen Reed case and tell her to do the right thing and all that stuff. Somebody was not telling the truth. It was either Dever or Cox. And when we're looking at it at that point, we have one person who's a commissioner. We have another who admits to creating a false memory. So whose credibility is already shot? Well, that's Kelly Dever. So we give Commissioner Cox the benefit of the doubt at that point. But then Corey Hopkins and Alan Jackson enter the room, and maybe that's changed. Maybe we were wrong. On July 10th, 25, Commissioner Cox publicly denied any connection to the Karen Reed case or to Officer Kelly Dever. Okay? July 10th, 2025. That's important. We're going to look at some documents here in a minute and when those are dated. But remember, July 10th, 2025. I'm going to write it down just in case I forget. Oh, I screwed that up. All right. He was asked about the allegation that he met with Dever before she was called to testify in the first Reed trial in 2024, and that he told her to do the right thing. In his unequivocal denial, Cox stated, "I have nothing to do with Karen Reed. Matter of fact, I didn't even know this person, Kelly Dever, was associated with the Karen Reed case." Then he doubled down. "I didn't know she," talking about Dever, "was even associated with that case. I was struck. Like, what do I have to do with the Karen Reed case? I've never said those words together." So the fact is, it's much ado about nothing. He doesn't seem concerned, surprised, taken aback to me when making these statements or these comments. And I said this before, like, we're getting the truth in black and white from the documents, right? The words on a page, and in living color nowadays with streaming, with interviews, with videos, with YouTube. Those statements were false, patently false. Commissioner Cox, the head of the Boston Police Department, actually asked, "What do I have to do with the Karen Reed case?" The answer is obvious, just the way Jackson writes, right? Kind of like how he speaks. One of his officers was dead, and the victim's body was discovered in the front yard of another Boston police officer. For the commissioner to suggest that he had nothing to do with the case defies logic and leadership. Common sense tells us he had everything to do with it. Newly obtained evidence, there it is, proves that Cox knowingly misrepresented, and you guys can be the judge whether you think he knowingly misrepresented or whether there's some room for misunderstanding or I wasn't sure or that's not how it happened. Misrepresented his involvement. On February 22nd, 2024, the FBI's Boston field office sent Commissioner Cox an email explicitly referencing Dever and the Reed investigation. Ruh-roh. The email from Assistant Special Agent in Charge Stephen Keller to Cox stated, we're going to look at this email. "Just a reminder, the documents were released to the DA's office late last night. The officer we spoke about is Kelly Dever." So let's take a look at this email. Because we can't just take people's words for it, right? Whether you like Alan Jackson or not. This is February 22nd, 2024, exactly as Jackson said, 6:23 at night, so it wasn't early in the morning. "Sir, hope all is well. Just a reminder, the documents were released to the DA's office late last night. The officer we spoke about is Kelly Dever. If you have any questions at all, feel free to call me. Steve." And this was to Michael Cox, Boston PD. Whoops. Okay. Also, this just like side note, when Hank Brennan was acting like the defense was in cahoots with the FBI and all this stuff is happening behind their back, I tend to think that there's plenty of emails like this where everybody was being kept up to date, everybody was on the same page, and the FBI had no reason to, lie to law enforcement or share something with Karen Reed's defense team that they weren't willing to share with law enforcement. Okay? So that email was on February 22nd at 6:23 p.m. when most government workers are no longer working, right? The very next day, February 23, 11 a.m., Cox's official calendar lists a meeting with Officer Kelly Dever, exactly as Dever would later testify and Cox would deny. The timeline is indisputable. Let's take a look at that calendar entry, which, by the way, it's very interesting that we have this calendar entry, right? Because it'd be a lot more difficult to get my calendar entry, but government workers, public officials, they work for you, the general public. So if you want to request, what are they doing? What's on their calendar? Well, guess what? February 23rd, 11 a.m. Eastern time, less than 24 hours later. I mean, what is that? 20 hours later from 6:23 p.m. He's already having a meeting with Kelly Dever, the exact officer listed in that email from the FBI. What are the chances of that? What are the chances of that? All right, so here we go. Sally, perfect. Thank you for this. This still leaves an opening for Cox and or Dever to say something like, okay, yeah, I forgot. We did meet. We did speak, but it was not about the Karen Reed case. Do you believe, people in the chat, that that misunderstanding is possible? Do you think it's likely? Do you think it's legitimate? I would say it's absolutely possible. But I would also say it somewhat defies logic and asks me to believe something that it's like if he would have had a meeting with Kelly Dever before the email from the FBI, I would say it's even potentially likely, probable. If he had it 6 months after the email from the FBI, I would say it leaves more room, potentially. It leaves more room for him to say, oh, no, that wasn't the connection there. But the fact that it's less than 24 hours later makes it possible, but highly unlikely to me. So if we're proving this, do we think we'd be able to prove this beyond a reasonable doubt? I don't know. I think I could prove it by a greater weight of the evidence. What's more likely than not, folks? That Cox met with Dever about what the email was less than 24 hours earlier, and in fact, that mentioned the Karen Reed investigation? It's definitely more likely than not, from my perspective. It's just one man's opinion. But feel free to let me know what you guys think in the chat. That's the whole point of this. How do you look at this? Especially if you're from Massachusetts. How does this make you feel, putting all of this together? Cox's televised claim that he had nothing to do with Karen Reed and didn't even know this person, Kelly Dever, was associated with Karen Reed, was a bald-faced lie. I always thought it was a bold-faced lie. Is it bald-face? That's interesting. Has it ever happened to you where like something you thought your whole life is wrong? Is it really a bald-faced lie? One now disproven by documentary evidence originating from the Federal Bureau of Investigations itself. I'll save that, the Proctor phone stuff. Kathy, thank you for gifting 5 Lawyer You Know memberships. Somebody else said they Googled it. Jen said she Googled it, thought it was bold as well, and apparently it is bald. I would assume he's correct and that I was wrong. I just made, that would be my assumption. But that's funny. As the head of the as the head of a law enforcement agency, Commissioner Cox is an officer pursuant to Massachusetts General Laws, Chapter 6E, Section 1. And there are some like issues with can the commissioner be on the Brady list? I'm not an expert on that, so I don't necessarily know. I'm not going to get into the weeds on that. Jackson thinks he should be on the Brady list, obviously. When a police commissioner lies about his own contacts with the FBI and meetings with an implicated officer, he forfeits the credibility and integrity his oath requires. So contacts with the FBI and meetings with implicated officers, that type of language, sometimes can be Jackson-like. That is the very definition of a Brady-Giglio violation. Under Brady v. Maryland and Giglio v. United States, the prosecutors have an affirmative duty to disclose any evidence of dishonesty by a government witness or official in every case where the official might either testify or influence the testimony of evidence provided by others. Commissioner Cox now fits squarely within that category, which begs another question for me. Why wasn't this turned over to Karen Reed's team? Why weren't these emails turned over? Why weren't these calendar entries turned over? Maybe they were. I don't know that they weren't. I shouldn't make that assumption. I don't think that they were. And if they weren't, why weren't they turned over as Brady? Why isn't that a Brady violation? And by the way, I promise you, no matter how anybody feels, myself included, about Massachusetts and the Commonwealth and law enforcement there, This is not the only place that this type of stuff happens, where we as defense attorneys just never know it exists. We never even know it exists until something like this happens. And that's a problem, and that's not how it should be. Accordingly, Commissioner Cox must be referred for immediate inclusion on the Brady list maintained by Suffolk County District Attorney's Office. In addition, the post-commission must initiate a full disciplinary review for dishonesty, lack of candor, and conduct unbecoming of an officer under Department Policy Section 102, which mandates that employees shall conduct themselves at all times, both on and off duty, in such a manner as to reflect most favorably on the department. This is not a political issue. It is a question of credibility and public trust. When Boston's top law enforcement officer lies about his knowledge of a case under federal scrutiny, the stain spreads across the entire system. Accountability cannot stop at the commissioner's door. The people of Massachusetts deserve law enforcement leaders who tell the truth, not those who hide behind it. In light of the documented evidence now in the public record, there is only one responsible course: add Commissioner Cox to the Brady list and open an immediate post-inquiry. So there's a couple obvious questions that most people have right after something like this happens. Number one is this just a PR stunt? Is this just Alan Jackson trying to blow more smoke and get in the media cycle again? And sure, part of this could be considered being done for PR. But from my perspective, I see it as lawyers doing what lawyers do. And what a lot of times people hate lawyers for doing it, especially if you don't support the cause that they're trying to push. But many times they're trying to push transparency, justice, fairness, and sometimes it's fairness for a guilty defendant, fairness for somebody that the public has already committed before a trial has happened that people don't care about the presumption of innocence for, right? A lot of times that's what lawyers are fighting for, but we fight for it in those cases so that it's applicable in these cases where you have somebody who was found not guilty. And we're seeing all of the problems that happen in the background that we don't know about. Additionally, I think it's incredibly important, and it's an incredibly job well done by Alan Jackson for the people of the Commonwealth of Massachusetts. Wouldn't you want to know this? Wouldn't you want this to become public? Wouldn't you want the media to report on things like this? I just before we started the stream did an interview with Ted Daniel. He is going to report on this. He is the first place I saw this. Local media need to report on this. The people there need to know, because either themselves or someone they love could be absolutely caught in the crosshairs and subject to the power and authority of these law enforcement officers or somebody in the control of these law enforcement officers. So wouldn't you want to know if Cox is involved or Proctor is involved or Buchanan's involved? No more Proctor, but wouldn't you want to know if these people are involved now? It's kind of an extension of the entire point of this channel, that people understand the justice system. They're not scared of it. They're not saying, oh no, I hope if this ever happens to me, I'm just going to curl up in a ball and whatever, just let them do their thing. No, understand how it works. Understand what lawyers should do and can do, how judges should act, how law enforcement should act in these scenarios, and understand what difference you can make. Talk to public officials. Go to your local events and town halls. Vote for people who have an effect on who the head prosecutors and judges and law enforcement may be in your area. You might think you're not going to make a difference. You might think it doesn't matter. It does. And if you sit there and do nothing for too long, it could look like this. And if nobody ever shines a light on it and talks about it, it could end up like this. And that's a major problem. So I appreciate shining the light whenever there is a problem, whenever there is corruption. Obviously, we all can't shine a light on every single problem in the world. So I'm going to get a lot of people emailing me, oh, you don't care about this, or you don't care about that, or you don't talk about this, or you don't talk about that. I get it. And I understand the frustration. I'm not mad at you about it. I get it. Everybody should be a really big fan of justice. We should be fanatics like we are about our teams. Knowing everything about our teams, we should know everything about the justice system. Knowing the rules of whatever sport we cheer for, we should know the rules of the justice system. That's the point. Michelle said, I always believed Dever was honest about meeting with Cox. They told her to lie about what she saw in the garage, but forgot to tell her to lie about the meeting. I could see where that was going, Michelle. I could see where that was going. Say something. Does this affect his employability? The commissioner seems unlikely to be a witness often. I agree with you. He's not going to do a lot of hands-on investigating, but he could be training. He could be a leader. He could be in meetings, and he could be called to impeach other officers for those meetings. And maybe he lies about those meetings, and he needs to be impeached with the lies he's told in the past about those meetings, or at least things that look like lies. The bald-faced lie thing is an example of an eggcorn. There's a word for everything. I love it. I love when stuff like that happens. I love it. All right. So that is the letter. And now we're going to get to a little situation or a continued situation for Michael Proctor that I think we'll eventually be hearing from Alan Jackson on again. I asked him, just imagine what it would be like to go through these texts. And he was like, can you believe it? Like, honestly, can you believe it? It's an unbelievable situation we have brewing here with the Michael Proctor phone scenario. And this is again posted by Ted Daniel. And the language used, okay, we don't ask for this language as people who talk about this stuff, okay? We don't ask for this language. But this language is what's put upon us and we need to discuss, okay? So what's going on? Well, the Commonwealth is filing a motion for a protective order regarding information derived from review of extraction of a former Massachusetts State Police trooper's personal phone. So they're moving for a protective order. What's the purpose of a protective order? Why do you want to do a protective order? A protective order is a legal mechanism to block unnecessary disclosures, okay? You can do a protective order if it's harassing, if it's overly broad, if it's irrelevant, if it could be damaging to somebody not involved in the case. We file protective orders all the time. Sometimes defense attorneys in civil cases where our client got rear-ended by a drunk driver and had a back surgery, and they try to get her gynecology records. It's like, come on, guys. We file for a protective order. And sometimes we get it, sometimes we don't. Depends on if there's some kind of correlation or something that could potentially lead to discoverable material. So it's not unusual that you file a protective order in these cases if you think there's something that may be damaging or harassing that could come from whatever is being requested and potentially disclosed. So I will tell you, and it may surprise you, there are going to be parts of this motion I absolutely agree with, and I think protective orders should be granted for parts of this Proctor download. Okay? What's the purpose? To hide all wrongdoing? No, not in other cases, right? Sure, you can try to use a protective order to block things unnecessarily or inappropriately, which then, yes, it would be to potentially hide some wrongdoing. But let's dig in. Let's read this motion. Let's talk about what's legitimate and what's not. If you can't read it because it's a little blurry, don't worry. I'm going to read every word. The Commonwealth moves pursuant to Massachusetts Rule of Criminal Procedure 14.2 that dissemination of materials from an extraction of former state police trooper Michael Proctor's personal cell phone is restricted. So it's not everything. Okay, we need to be clear about that. As grounds on June 17, 25, this court, Michael P. Doolin, in specific cases, allowed in part defense motions for discovery of former Massachusetts State Police Trooper Michael Proctor's personal cell phone. The order included that the Commonwealth produce communications from the dates of the charged offenses to the dates that indictments issued and produce any other data from Proctor's personal cell phone that constitutes investigative materials or is favorable to the defense within the meaning of Massachusetts Rule of Criminal Procedure 14. The court further ordered that the Commonwealth may move for an appropriate protective order for the court's review prior to producing the items and information that defense counsel shall not show, provide the communications produced. Let me make sure this is the right. Yeah. Communications produced pursuant to this order to anyone else except that defense counsel may show, but not give them to the defendants in this case. So we knew protective orders were coming. Okay. We knew it. The judge basically requested it. And when the judge requests something like that, whoever he tells you can file for a protective order is going to do that, because that's a little hint, hint, wink, wink, that I realize all of this is not going to be needed to be produced. Upon filing of a motion and amended motion for clarification by the former Troopers Counsel on August 13, 25, this court, Peter Krupp, clarified that the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range. Woof, that was not a great one for them. And that the former trooper had a legitimate interest in protecting attorney-client or spousal communications. So is that what we're talking about? Is that the only thing we're going to protect? No. The court issued further orders about delivery and extraction of the phone, the opportunity for the former Troopers Counsel to submit a privilege log, which we know happened, and a timeline for the Commonwealth to produce discoverable materials. Under Massachusetts law, all items and information favorable to the defendant within the possession, custody, or control of the prosecutor, prosecuting officer, or prosecution team must be disclosed. Review of the personal cell phone is ongoing. At this time, pursuant to Rule 14, the Commonwealth is producing text chains, audio files, and video files, which span many years. One text chain contains, and here we go, okay? They're producing this information, and it spans many years. But one text chain contains highly sensitive information, including images of intimate body parts of people not participating in the chat. So that to me leaves out Proctor, right? Because I know people were saying, oh, what's Proctor sending? What's going on with this? And so it doesn't seem like it's Proctor sending anything. It also doesn't seem like it's a conversation between Proctor and somebody else sending each other nudes, right? But this opens up Proctor's box even more, because the potential of this could be so damaging to Proctor and others. If it's truly somebody that has nothing to do with this conversation, of course, this protective order should be granted. If it's, I don't know, somebody sent Proctor a nude photo that he sent to a friend or somebody else, regardless of what we think, morally speaking, about mistresses or cheating or online promiscuity, right? Downloading certain pictures online and sending them to a friend. To me, generally those, I understand why a protective order would be granted for those people, because this is going to be seen by thousands of people potentially. So I get it. But context is so important, and the judge needs to look at context, because if Proctor is sending Buchanan or officers on other cases pictures with comments that would call into question investigations or defendants or victims, any analogies or comments comparing, contrasting what this person looks like or acts like or would be like, or making fun of them or ripping them or hitting on them, that's problematic. That's problematic, and that needs to be discovered. Again, what's discovered to the defense and potentially discoverable and usable at trial is different than maybe public disclosure for all of us to see. We don't need to see nude pictures of victims or witnesses or defendants or people involved. We don't need to see that publicly. To know they exist is important, and how Proctor was using them or talking about them may be important, because you could see how questions of cross-examination and credibility could be used. How did you get these pictures? Why were you spreading them around? Who was talking about them? What were they saying? Did your supervisor know? What did they do about it? How did they train you on how to handle this? So it's going to be really important, the context around these, but we know that there are intimate body parts contained in these text chains by non-participants. Then we have full phone numbers and or personal email addresses of the text chain participants and the name of SA victims. So again, maybe that name needs to be redacted, but I hate to say it, I can see scenarios where their conversations about victims could be potentially relevant for credibility, for investigative techniques. Okay, under Massachusetts Rule of Criminal Procedure 14.2G, upon a sufficient showing, the judge may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. So they could say, absolutely not, you don't even have to disclose this, or you do have to disclose this, but we're going to restrict public access and have some kind of confidentiality agreement, or the public can know about it but not see it. You can discuss it but not show them the picture or video or whatever it might be. They could be crime scene photos, which would be problematic for another reason, which we'll talk about in a second. The judge may alter the time requirements. The judge may, for cause shown, grant discovery to a defendant on the condition that the material is to be discovered be available only to counsel for the defendant. This provision does not alter the allocation of the burden of proof with regard to the matter at issue, including privilege. Actually, let's pause now, and we'll come back to this in a second and finish. And we're going to give some more credit here to Twitter. It can be a great place. It can be a horrible place. It can be a great place. Our guy, Mark Betterow, on Twitter, astutely pointed out, under MGL 41, Section 97D, if disgraced former trooper Proctor shared confidential information about an SA victim, including her name or even just a record of the report itself with a third party, which was not necessary in the performance of his duty, then he committed a crime punishable by up to a year in jail. Could it be? Could that be correct? Or is Betterow just a Twitter lawyer? Let's take a look at Section 97D, the bottom part. Communications between police officers and victims of said offenses and abuse may also be shared with the foregoing named persons if such access is necessary in the performance of their duties. A violation of this section shall, not may, but if you violate this section, you shall be punished by imprisonment for not more than a year, or by a fine of not more than $1,000, or both such fine and imprisonment. Shocker. Betterow was right. This is not great for Michael Proctor if that's the scenario here. We don't know yet, and we'll have to see. This reminds me of the Kobe Bryant situation, right? Where you have, I think it was EMS in that case, may have been law enforcement sharing pictures with their friends because it's a celebrity. Inappropriate, sued, huge verdict. Civilly, I don't know if any criminal punishment came for those people, but you can't do stuff like that. You just can't. It's totally inappropriate. And if you do, you should be punished, and we need to deter people from doing that in the future. Cora, Proctor phone records going back to 2013. Does that mean cases he's investigated going back to 2013 will be reopened/investigated? I think it's possible, but on the other hand, it's like, will any of those lawyers or defendants ever get access to that? Or is the Commonwealth going to say, oh, none of that's relevant to any of the cases we're working on right now currently? And would judges really be open to reopening any cases in the past for something like this? Is sending them a crime? It sure sounds like it could be. We need to find out some more context. Jamie said, Peter, I passed the bar. What a relief, Jamie. It's not just a relief. It's an accomplishment. Congratulations. I'm pumped for you. Fight for justice. Fight for it. Unwaveringly. Okay, let's get back to this motion here. Charlie, gifted 5 membership. Thank you. The issuance of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures. And if that is what the judge determines them to be, absolutely, I agree with the Commonwealth, and a protective order should be issued. We need to protect those people from this madness. We really do. Those of us who want to come out here and talk about it publicly, we open ourselves up to it. And I understand. People are going to have a lot of things to say about me. I get it. They're going to have a lot of things to say about Hank Brennan and Proctor and Jackson and Turtle Boy and Betterow. Like, we get it. We talk about this case, we choose to. Those people should not have to have the same happen to them, especially if they're victims of crimes that Proctor investigated. Non-parties have a privacy interest in not having their images, their complete cell phone numbers or email numbers publicly displayed. Names of victims in court records or police reports may not be disseminated except with the consent of a justice of such court where the complaint or indictment is or would be prosecuted and are otherwise withheld from public inspection. Reports of SA shall not be public reports. And of course, we all agree with that. Further, non-participants who appear within the produced materials may have a security interest in not having their personal identifiable information released to protect against harassment. Again, I 100% agree with that, regardless of what you think. And I know there's some people, and I know some stuff happened with like Lucky, and it's like we need to be careful because these people and what happened to them could be involved and could be relevant, but their information potentially not. That's important. That's important that we need to be able to see the distinction. And the law is not so rigid that it doesn't leave the opening for judicial discretion. In perhaps Proctor was spreading things about a victim without us knowing who the victim is or what they look like or what the case was, right? I'm not saying that happened. I'm just saying we can have that kind of nuance. Kim, yes, everybody hit that like button, please. And thank you. And subscribe to our channel if you have not. Take a second, subscribe. We'd love to have you. And then they cite a case that says, while the Commonwealth bears the burden of demonstrating the risk of safety, it need not demonstrate a specific or actual threat where danger to witness safety is inherent in the situation. I think that's a pretty easy one to prove in this case, that there is the potential for harassment. Ashley, could the SA victim be notified and sued because of it? I think the answer to that should be yes, but I don't know that they would have to notify them. I think they should know, and I think they would have a really great claim. Further, where such information was provided upon court order in specific cases and dissemination was subject to restrictions as a condition of its release, this court should order similar restrictions prior to the production of the materials in this case, and I agree. The judge needs to look, and there's probably some either restricted access or no access to some of this information before it's disclosed to the defense and especially the public. This court should order similar restrictions prior to the production of the materials in this case. Accordingly, there is good cause to limit dissemination to one copy, that further copying be prohibited, that the materials be shown but not provided to the defendant, and that the materials are not otherwise disseminated outside the criminal case. Meaning, we may never see some of these materials. I agree with that. As much as it sucks, as much as I'd like to see everything and know all the context, I do think that there could be some scenarios here based on the filings and what it sounds like dealing with these victims that some really need to be restricted, appropriately restricted. The materials will be provided in an electronic format with text chains including embedded audio files. Where the text chains include the name of an SA victim, see this rule, the Commonwealth requires that it be allowed to omit the electronic version of the messages that include a SA victim name from the electronic production so as to redact the SA victim's name and provide as a PDF. And we know that there are other cases, Betterow included and Turtle Boy's case included, that they're trying to block some of this. They're not going to want to turn some of this over. And we also have seen some things come out that while Proctor may not have investigated Turtle Boy's case, he's copied on some emails where they discuss it, where Buchanan discusses it. And do we think Proctor really hasn't ever said anything about Turtle Boy in his personal text messages? It's just a guess, a wild guess. My wild guess would be there's probably something in there about it. Review of the extraction is ongoing. There may be additional materials that the Commonwealth will provide under Rule 14 to streamline future discovery. The Commonwealth requests, as set forth in the appended proposed protective order, that where the Commonwealth believes there is good cause, future production of materials from extraction be redacted or limited to the defendant's counsel, and dissemination of such much materials be prohibited outside the criminal proceeding, limited without prejudice to a motion to modify the protective order by either party on good cause stated. Okay, it was kind of a clunky ending there, but you get the point there. So I think that this should be granted at least somewhat, right? And we need to kind of see where it goes from there and what can be learned from there, because it is important. And also, when we're talking about harassment, because that's something we don't want. And when you have people that, may be involved here, maybe witnesses, maybe victims of Proctor, maybe victims discussed with Proctor, and even, who this is going to get turned over to. Will this get turned over to Better Owen Turtle Boy's case? Will this get turned over to other cases and past cases? And are we afraid of them getting harassed? And I think that's important. But we have to remember that calling out wrongdoing and highlighting misconduct, and here's what I would say, Proctor's a good example. I think a lot of what Proctor is getting is not harassment, legally speaking, and illegal. I think some probably is. Some people probably take it too far. I don't know, and I'm not thinking about anything specifically or one comment or another, but we have to remember that calling out wrongdoing and highlighting injustice and highlighting misconduct is not the legal definition of harassment. Because harassment, legally speaking, in order for it to be, a crime, it has to be basically willful conduct on purpose, intentional conduct directed at a person that a reasonable person would think was, of course, annoying, tormenting, terrorizing, those types of things that are in legal harassment and not, but they serve no legitimate purpose, no legal purpose, no purpose highlighting misconduct or fighting for justice. And what is a legitimate purpose can be argued about and can be something that potentially is not good for someone charged with harassment. So it's important that we understand what is harassment and what is not. So I think that the judges should look at these Proctora's box here and make a case-by-case determination looking at the totality of the circumstances. What's the context? How far removed is it? Is it potentially discoverable? Is it something that's good for the defense? Is it something that hurts Proctor or Buchanan or somebody else on this group chat's credibility that is going to be necessary for the defense to use during cross-examination? And if it is, it needs to be discovered. It needs to be turned over. It needs to be produced. It really does. Jan said, in honor of my daughter passing the New York bar and starting her law career in New York City, they need it. Congratulations. I encourage her to reach out to Better Owen. He's been practicing there for a long time and may be a good resource for her. Kraft, thank you for bringing this up. I want to talk about this on stream, but kept forgetting. Peter, sent you an email about a YouTube channel that's impersonating you. It's starting to get a lot of traction, reposting your streams 4 hours ago. Yes, I have seen this YouTube channel. A lot of you have sent it to me and reached out to me. I appreciate it so much. We have reported it. You guys have reported it. We've also done something we've never done before, which is try to copyright strike them. I hate copyright strikes personally. I've had people make fun of my channels, disagree with me, rip me to pieces. You guys have posted, people who kind of joke with my channels or whatever, or with my videos. That doesn't bother me. I consider that fair use. As long as you're making it your own, whether it's parody, whether it's reacting to, responding to, making fun of, making light of, whatever. Okay. I'm fine with that. But just taking a video and reposting it and creating an entire channel of it with me on your banner, right? It's just weird. It sucks. It's annoying. So we copyright struck them. We won some automatically. Sometimes like, we need more information. Prove this is you. I'm like, seriously? This seems pretty obvious. Like you didn't even change the title. So that's annoying. And there's another channel now that has done the same thing and it's annoying. We're working on it. I've had some other creators reach out to me and how they've dealt with it in the past, which I really appreciate it. I really appreciate all of you guys reporting it. Please do that and continue to do that. And I see a lot of you guys commenting like, this is fake, this isn't Peter. And then I see some videos with comments that people are clearly think it is me and commenting and trying to engage with me. And of course it's not. I hate that. I can only imagine they're going to try to start spamming them with some crypto scheme. And I really hope nobody from our community falls for that. I hate to think that that's the most annoying thing about it. I don't even care that they're getting views on videos of me. It's like the people that believe it's me and that talk to this person and may get duped by this person. That's what I hate most. And I'm trying to do everything I can to fight against that. So I'm glad I was able to also talk about it on stream. Thank you for that. And Beagle Rescue Mom, another thing I want to talk about on stream. Peter, have you looked at the Abby Zwerner civil case? Teacher shot by student, suing principal. Criminal case is still pending. Yes, I have seen this, and I actually don't know a ton about it. So I wanted to watch opening statements, which are today. If I had to guess, I think I am going to do some recaps on this case. I don't know if it'll be daily or if it'll be weekly or every couple of days. I don't know how long the trial is supposed to go, but it is a civil trial. I find it incredibly interesting. It is a question you guys have had on every single case like this. What about the school? What about the principal? What scenario would they be liable? What scenario would they be at fault? Right? Because we've had, obviously, the person, the shooter, be held liable in different ways. We've had the parents. We've seen that. And now we're actually seeing a trial where school employees, things like that. To me, that's really important. And I think this is one that I want to follow. And hopefully you guys will follow with me. I have had a lot of questions, but never know what's going to interest you guys. So hopefully this one does. If it does, let me know in the comments. Let me know by liking this video, and then come check out those videos when we post them. Okay. We'll end with this. Peter, bold-faced lie, it must be commonly misused in the South. That's where I am technically, even though people think Florida is not the South. Okay. I appreciate you guys so much coming to hang out with me for this lunchtime live. Hope you have a great rest of your Tuesday. We have more videos coming this week, including check out the Ted Daniel interview I did, where it's a back and forth with he and I. So there's some different stuff that I talked about in here. Make sure you check that out and go comment that you came from the Lawyer You Know channel and you're coming to check out and support Ted and their channel as well, and encouraging local media to report on this stuff and to shine a light on this stuff because they don't have to. And I'm glad they do. So I appreciate you guys so much. Thanks for being here with me. Hit that like button, subscribe on the way out. Till next time, I'm out of here. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.